The Supreme Court decision in the case of People of the Philippines versus Eduardo DELA CRUZ. We now reckon with the allegation and the information that Maria, not her real name, is a special child. The trial court concluded that Maria was a child based on her appearance and demeanor during the trial. It particularly noted that on the witness stand, she murmured,
"Hindi na ba ako babalik, uuwi na ba ako?"
According to the trial court, such action is attributed to a child of tender age. Further, the trial court took into consideration that the defense did not object to the treatment of Maria as a child witness. Consequently, both the trial court and the Court of Appeals were convinced that DELA CRUZ should be held liable for statutory rape under Article 266, of Paragraph 1D of the Revised Penal Code. We note that while the trial court did observe that based on the appearance and demeanor of Maria during the trial, she was a child, it failed to identify or at least calculate her mental age. Also, the records did not bear any clinical identification of her mental age either. Verily, therefore, there is nothing to support the conclusion that the 16-year-old Maria had a mental age of a child below 12 years old at the time she was raped to sustain a conviction for statutory rape. In People versus XXX, the mental disability of the victim was not disputed. However, the victim's level of disability has not been equated to a specific mental age. The medical certificate merely stated that the victim is suffering from moderate retardation. In ruling that there was no statutory rape, the court ordained that the mental age of the victim must first be identified. Namely, evidence must be adduced to aid the court in determining not only the existence of the illness and its level of severity, but as well of its manifestations and the corresponding mental age of the subject. The determination of mental retardation, particularly the degrees thereof, is deeply rooted in medical psychology. As such, courts are largely dependent upon psychometric evaluation. It is true that such mental condition can be proved by evidence other than medical and clinical evidence, such as the testimony of witnesses and the observation of the trial court. This may be sufficient when the issue is the ability of subject to testify in court or to stand trial, the only consideration being the ability to comprehend the questions propounded and to respond to the same intelligibly. However, when the determination of mental disability constitutes as an element of the crime of rape, or when a victim's mental age is necessary in characterizing whether carnal knowledge can be considered as statutory rape, or when mental disability relates to the capacity of the accused to commit the crime, the same must be medically defined and specified, over which the court must rely upon the findings and evaluation of experts in the field, social workers, or persons close to the subject, sufficiently averring circumstances to depict the mental development and status. In the same way, the court cannot merely rely upon the comparative classification of mental age vis-a-vis the level of mental retardation of a person provided for in DELANDAs, as past cases show us that mental aging is variable. And ultimately, the conviction of an accused of rape based on the mental retardation of the victim must be anchored on proof beyond reasonable doubt and not on mere inferences. Courts cannot hastily resort to deductive reasoning with respect to the proper designation of the crime. The rule must be that in order to be properly appreciated, mental retardation, particularly when disputed, whether of the victim or of the accused, must be sufficiently characterized by adducing evidence stating the intelligence quotient, manifestations of the illness, and mental age. The nature of a crime, including its mode of commission, must be sufficiently alleged as to allow the accused to adequately prepare for his or her defense. This requirement is vital in all criminal prosecutions, as it is deeply rooted on one's constitutional rights to due process and presumption of innocence. While, admittedly, the penalty provided for by law is the same in any of the circumstances under Article 266, Number 1 of the Revised Penal Code, this fact alone does not diminish the substance of the requirement nor of the importance of the rule's observance. Whereas a victim's chronological age is factual and evidentiary in nature, which must be established by evidence during trial. Comparatively, the same also holds true even more with the determination of the mental age of a person suffering from mental retardation, as it is primarily a scientific and a medical issue. As such, it must be properly characterized and substantiated by medical evaluation or by adequate proof, external manifestations of the person allegedly suffering from mental retardation. But this identification need not be based alone on the existence of a clinical or medical finding on record. In fact, the court emphasized in People v. Burmas that the lack of medical or clinical evidence does not preclude the presentation of other evidence to prove the victim's mental disability. Medical finding is necessary only for borderline cases when there is difficulty in ascertaining the mental capacity of the victim. In cases where the cognitive disability is readily apparent, the trial court can resort to other pieces of evidence. Consequently, People v. Dumanon pronounced that the trial court itself can determine whether a person is suffering from mental disability. People v. DeLandes also recognize that the mental disability of persons and the degrees thereof may be manifested by their overt acts, appearance, attitude, and behavior. To repeat, the trial court here made its own observation that Maria was a child based on her appearance and demeanor, but failed to identify her mental age to support a conviction for statutory rape. This is significant considering that under the law then prevailing, statutory rape involved child victims who were below 12 years of age. Hence, in cases of statutory rape involving victims with cognitive deficiency, their mental age corresponding to that of a child below 12 years of age should be established. As shown here, the mental age of Maria was not proved. Thus, DELA CRUZ should be adjudged guilty not of statutory rape, but of rape under Article 266 of Paragraph 1 of the Revised Penal Code. To recall, DELA CRUZ succeeded in having carnal knowledge of Maria by using force or intimidation in the form of moral ascendancy. Maria called him Uncle Edward. 2. The big discrepancy between their ages, that is 40 years old vis-a-vis 16 years old, is indicative of coercion. Further, as a full-grown adult, DELA CRUZ took advantage of Maria, who was not only a minor, but was even afflicted with cognitive disability. He even testified that he knew of her mental state because she is roaming around and she's doing like this. The witness is shaking his body. He further observed that it's like Maria doesn't have a mind. She is mentally disordered.